For those of you who are watching this in recorded version, the notes had not been posted on Canvas prior to the lecture, but they have been posted now. So if you're watching this right after the lecture, you should be fine. Once again, I'm having mask problems. So the new federalism. We have been looking over the last couple lectures at the ways in which the Rehnquist court onward, basically the Rehnquist court and the Roberts court, the contemporary court, has been reshaping constitutional doctrine in core areas. And we looked at the Commerce Clause and we looked at 14.5. And in both of those contexts, we saw the current Supreme Court making substantial changes to what had been long settled doctrine. In the case of the Commerce Clause, and Lopez in particular, Lopez and Morrison and Raich, but in the case of, I suggested, and of course these are always my suggestions, your job as students is to learn the material, not to accept my characterization of the material, but I offer these. I suggested it was kind of a weak revolution. What is going on here? A weak revolution. That the change in rhetoric and reasoning was very substantial. That the test is quite different. This whole economic, non-economic formal distinction is quite new, at least since the 1930s. But especially after Raich, the effect in terms of restricting what the federal government can do is not all that great. A little bit, it goes back to something we talked about during the Lochner era, which is this idea of a version of conservatism in its literal sense, meaning conserving. That is, the new rules don't say the federal government can't do things it's always been doing, but they may discourage experimentation. They may provide a signpost, what you're doing is fine or it's acceptable, but don't go too far. Don't push this boundary. And so we were establishing the outer bound. And the outer bound that we're establishing is one that doesn't infringe on long established practices all that much, maybe a little bit, but that, for example, the Gun-Free Schools Act, maybe that'll help, who knows, that the Gun-Free Schools Act, was pushing into, in the court's view, was pushing into new areas, and that's what we're going to clamp down on. In the 14.5 context, it was different. There had never been, in the modern era, since the 1960s, a question about Congress's authority to act boldly and creatively in enforcing civil rights. This was not merely a matter of saying you can do what you're doing but don't go any further. It was clawing back a considerable portion of that authority, not so much in terms of you may do X or you may not do Y, but in terms of, again, the tests, the rhetoric, and the reasoning, and a strong revival of state sovereignty and what Roberts called federalism concerns, which would be an independent check. And now, this is an important point. One of the things we saw in the Commerce Clause context, that black box, remember usury, in the center of the Venn diagram, even where powers are granted to Congress by Article 1, they may be limited by principles of federalism. In the 14.5 context, it was the same thing. Even though we recognize that Congress has powers under 14.5 to do X, Y, and Z, in each particular instance, we're going to balance that against these federalism concerns, which had not been part of the equation for a very long time. Again, though, at least, there's a way to read Shelby County. You can read Shelby County as the effective, which is what Thomas called for, the effective destruction of the Voting Rights Act. And Thomas said, look, let's just abolish the whole idea of preclearance altogether. And you can say that the tests that the court established and the focus on federalism and the idea that Congress's evidence wasn't sufficient, and that there was a problem with treating 9 states differently from 41 other states, and all of that, which was all kind of novel, you can view that as undercutting Congress's authority to enforce 14.5 in a really profound way. Or, if you want to be more, I don't know, is charitable the right word? Generous? You could read it a different way. You could say, no. All Shelby County really stands for is the proposition that Congress has to go through the effort of specifying the justification for what it's doing. Certainly, Shelby County says very explicitly we're not going to be deferential in reviewing that action. Certainly the standard of deference is much lower than it's been in the past. But in principle, you could read Shelby County to say that doesn't mean Congress can't meet that new standard of deference. They can make a new coverage formula. And if it's politically impossible for Congress to do that, well, that's not the court's problem. That's the nature of American politics, right? You can read it that way. So in both the Commerce Clause and the 14.5 context, you can read these new cases and their new principles as altering the equation and altering the approach, but not necessarily dramatically altering the outcome. You know, if you were confronted by a new 14.5 law passed by Congress and asked, is it constitutional? You wouldn't necessarily say, well, because we shall be counting, the answer must be no. You'd apply the new tests. Today's material is different. In what has been called the new federalism, the current court has simply established new, hitherto unknown limitations on the authority of the national government that substantively reduce authority in a wide variety of areas that has been exercised for most of the past century. The reasoning is the restoring of state sovereignty. And again, I go back to the speech that Reagan gave in '81 that I read you a short excerpt from, where he said, we are going to restore sovereignty. I'm going to appoint judges and justices who will restore state sovereignty to get back to the proper order in which the states are the bricks and the national government is the mortar, and away from, right, he didn't spell this out, but the implication is the erroneous order that's been in place since the 1930s and the New Deal. Well, the word we've been using is revolution. That significant change gets teeth in the material we're talking about today, even if you think it didn't, in particular, in the previous ones. Although most people think that those were also pretty severe restrictions. So we start with a brand new principle. And there's just no other way to put this. This is new. The anti-federalists didn't talk about this. You know how much I like to draw everything back to the beginning and say, it's all the same debate. Nope, this is just brand new. Anti-commandeering. It would violate some constitutional principle of federalism and state sovereignty for the national government to make use of, I'm going to say this carefully, to make use of the state government as an instrument of federal policy. That would be commandeering is the term. The national government may not commandeer the resources of the state government to carry out national policy. That's the basic concept. It'll probably be clearer if we dig into a case. So the Brady Bill. The Brady Bill was a national gun control law that required background checks for the purchases of I think it was only handguns, but anyway, for guns of a certain set of categories. The federal law, and again, I'll walk through this carefully, the federal law required state officials, local police, sheriffs, to maintain databases and to run the checks, the background checks of people's, actually that's not true, I'm sorry. No, sorry. I believe that is incorrect. It's a federal database, but the local officials were required to run the names through the federal database. So you want to buy a gun, you go to your local gun store, you fill out a form, it goes to the local police department, they punch the name into a federal database. Sorry, you've got a felony conviction, you can't buy a gun, right? Okay. That was ruled unconstitutional on the theory that the federal government was forcing state officials, local police departments, to carry out federal policy. Everybody get the concept? Okay. Let's pause a second. I asserted that this is brand new. Am I being reasonable in saying that? Well, let me try and support my own argument. First, consider the militia clauses. The state militias can be called into action to enforce federal law. It's in the Constitution. It's a specific function of state militias. They can be called into federal service to enforce federal law. That is as specific and explicit a mandate to make use of state actors to enforce federal policy as can be imagined, isn't it? Secondly, Commerce Clause. Federal government can pass all kinds of laws, and it doesn't even need to pass laws. The Dormant Commerce Clause can have this effect, to prevent state officials from doing various things based on various state laws. That would seem, at least this is the argument that I'm making, to be an example of making use of controlling the actions of state officials to carry out federal policy. Third example, the Supremacy Clause, which specifically states in the text of the Constitution, state judges may not enforce state laws that conflict with federal law, the Constitution, or treaties. Remember the Supremacy Clause of Article 6? That seems to be a direct, explicit, and specific direction to control the actions of state actors. So what's different here? Scalia writes the opinions 5-4. And he starts by pointing out that this is a matter that has to be resolved by reasoning from silence. Because as he says, nothing in the Constitution actually addresses this question, which you'd think would be a major admission for someone who's devoted to textualism and originalism, but apparently not. Because there is no constitutional text speaking to this precise question, the answer to the challenge, CLEO is a Committee of Law Enforcement Officials. Not committee, commission, council, I think. The CLEO's challenge must be sought in historical understanding and practice, in the structure of the Constitution and in the jurisprudence of this court. So historical practice, if we've always done it this way, it must be okay. We've seen that version. Here's a new version. If we haven't done it this way, it must be unconstitutional. This is that idea of prohibiting experimentation or novel actions. Second, structure of the Constitution. There are implied principles, federalism and state sovereignty. The word sovereignty does not appear in the Constitution. As Wilson pointed out a long time ago, the word federalism does not appear in the Constitution. There's no provision in the Constitution that talks about states retaining authorities despite grants. None of that. But, Scalia's argument goes, this general structure of the Constitution tells us that there's an intention to have a certain kind of federal structure. And third, the jurisprudence of this court, past cases. That one's a little bit difficult here because there are no past cases announcing this rule. So, one question that I have in the notes is, what theory of interpretation is this, and would you want to apply it elsewhere? So if there's no enumerated power, according to strict textualists at least, right? Remember the debates about what does Article 1, Section 8 mean, and what does necessary and proper clause do? And the narrow reading of congressional powers always was, if there's no enumerated power, Congress doesn't have that. The federal government doesn't have that power. Now we're saying, if there's no enumerated limitation on power, we might nonetheless find one. That's that black box in the middle of the Venn diagram. That even though the Constitution says Congress may do X, Y, Z, we're going to find an implied limitation on the exercise of that power. And in that sense, this is once again a limitation not on what the Constitution does, but what it can do. That is, given the structure of our Constitution, it could not grant to the federal government in usury the power to regulate states as states, here the power to commandeer state resources. So let's apply this approach to reasoning, historical understanding and practice. And he looks at some early federal statutes under the Supremacy Clause that had to do with telling state court judges they couldn't enforce laws that conflicted with federal law, right? Aha, says Scalia. Now I just presented that as one example that I argued suggests this is a new idea. No, says Scalia, because those laws only apply to courts. So it's not about commandeering states, it's about a rule against commandeering particular pieces of the state government. Those early laws establish at most that the Constitution was originally understood to permit imposition of an obligation on state judges to enforce federal prescriptions. Indeed, it can be argued that the numerousness of these statutes contrasted with the utter lack of statutes imposing obligations on the state's executive suggests an assumed absence of such power. So if in our early historical practice we don't see examples of Congress doing a thing, that's an argument to say that Congress is prohibited from doing that thing. This is a new version of an old argument. The old argument was, if we've always done it that way, it must be okay. Now it's, if we didn't do it this way, it must be unconstitutional. And the obvious question is, why are state courts not part of the states for this commentary? Why does it matter which branch of the state government is being affected? He talks about another challenge which is raised, which is that in the Federalist Papers, there's a specific discussion of the fact that the federal government will have the power to use state officials to collect taxes. Remember that prior to the 16th Amendment, early on, the idea was the federal government imposed taxes on the states and the states collected it. And it was up to the states to do the collecting. And you remember that some anti-federalist writers, I believe it was Brutus, was particularly concerned that this power of taxation would become the basis for an overweening federal authority. Does all this familiar? Remember all this stuff? Right? So why isn't that an obvious example that at least the writers of the Federalist Papers envisioned specifically the federal government using the state's executive branch to carry out federal policy? No, no. Because none of these statements necessarily implies that Congress could impose these responsibilities without the consent of the states. They appear to rest on the natural assumption that the states would consent to allowing their officials to assist the federal government. So notice the progression of arguments. First, we're looking for a limitation on a power that we acknowledge is granted by the Constitution, and we find it by an implied principle from the structure. And we look at historical practice. Second, yes, it is true historical practice permitted the commandeering of state courts, but that's just courts. This is the executive. Well, third, yes, it's also true that historical practice permitted the commandeering of state executive officials, but we can assume, just assume, that there is an implied assumption that could only be permitted with the consent of the states. Just cause. The obvious question, as I have in the notes, is what was supposed to happen if the states refused to collect those taxes? Is Scalia's suggestion that the idea in the Federalist Papers was that the federal government can use state officials to collect taxes with our consent, and if they don't consent, therefore the federal government cannot collect taxes, or has to create its own tax collecting function, which is not one of the enumerated powers. Right? But if you combine this with the commitment to a narrow reading of powers under Article 1, Section 8, the idea is that without state consents, the federal government couldn't collect taxes at all, which seems like a curious conclusion to read from the authors of the Federalist Papers. Why? As I've said, state sovereignty, but more specifically, see if this sounds familiar, it is incontestable that the Constitution established a system of dual sovereignty. Dual citizenship, dual sovereignty, we are back to slaughterhouse. Although the states surrendered many of their powers to the new federal government, notice the states surrendered their powers. This is the compact theory. This is not what Lincoln said. Lincoln said the Union was older than the states. It's not what Wilson said or Chase said or Story said. It's not what Jay said. It's not what the earlier Federalist, it's not the Federalist view, it's the anti-Federalist view. That the states exist as sovereign entities since the Declaration of Independence, and the federal government was formed by these sovereign entities surrendering certain powers in a treaty, effectively. The states surrendered many of their powers to the new federal government. They retained a residual and inviolable sovereignty. Right? This is that restriction on what the Constitution can do. In the act of creating the Constitution, states retained inviolable sovereignty. Some core principle, very much like usury, something about states as states, something about the nature of being states, sovereign entities, that could not be infringed upon by this act of creating the Constitution. Residual state sovereignty was also implicit, of course, in the Constitution's conferral upon Congress of not all governmental powers, but only discrete enumerated ones. Right? So it's implied by the enumerated powers doctrine, but that's not the basis here. On the contrary, the enumerated powers doctrine is being pointed to as an expression, illustration, of a deeper and more important principle of states being sovereign entities. The Constitution does not leave to speculate who is to administer the laws passed by Congress. The Brady Act effectively transfers this responsibility to thousands of CLEOs in the 50 states who are left to implement the program without meaningful presidential control. So, unitary executive argument. It's the executive's job to enforce and execute the laws, right? And what is the core of the executive function? Discretion. To decide when not to enforce the laws, as well as how to engage in enforcing them. If we allow Congress to have state police entities run these names through this database, that removes the president's control over how or whether to enforce these particular laws. What about the necessary and proper clause, right? Well, the age-old argument back to Marshall, that the necessary and proper clause implies that the limits of congressional, I'm having a real trouble with this mask, that the necessary and proper clause implies that the determination of limitations on Congress's power is effectively a political question, not one suitable for legal determination by judges at all. I mean, right, in Gibbons, he comes within a hair of saying that. And he certainly points in that direction, as did others. No. State sovereignty is a defining limitation on the necessary and proper clause. When a law for carrying into execution the Commerce Clause violates the principle of state sovereignty reflected in the various constitutional provisions we mentioned earlier, it is not a law proper for carrying into execution the Commerce Clause. So the term proper now has teeth, and it revives usury. A law is only a proper execution of federal authority, I'm just going to leave it like this, I'm sorry, is only a proper execution of federal authority if it does not infringe on this core principle of state sovereignty. What is that principle? Well, in usury, it was about states as states in certain key functions. That was rejected in Garcia because Blackmun changed his mind, and he pointed out all these examples that go one way and the other way, and he said, look, there's no clear principle here. Now we have a clear principle. You can't use, the clear principle is no matter what you're doing, you can't use state personnel to do it. Or at least not the executive branch. You can't use the state's executive branch to do it. Now there's a case we didn't read called New York versus United States. I'm going to skip that point because we didn't read that case. My apologies. It had to do with disposal of nuclear waste and an interstate compact for dealing with that problem. There was a federal law that said that states have the option of either joining one of these compacts, these multi-state compacts, for dealing with a problem, or they would be forced to take responsibility for the disposal of the waste themselves. That was ruled unconstitutional on the grounds that it was that was one of the first major anti-commandeering cases, because it had the effect of forcing the states to carry out federal policy. This law doesn't do that, but it uses state personnel to carry out federal policy. I won't skip it. We held in New York that Congress cannot compel the states to enact or enforce a federal regulatory program. Today we hold Congress cannot circumvent that prohibition by conscripting the state's officers directly. So you can't tell states what kind of policies to have, and you can't use state personnel to carry out federal policy. This is, after all, fundamental to the unitary executive theory. The insistence of the framers upon unity in the federal executive is well known. Actually, you and I know that that was a subject of hot debate and considerable disagreement. But whatever. That unity would be shattered and the power of the president would be subject to reduction if Congress could act as effectively without the president as with him by simply requiring state officers to execute its laws. So the core here, it's a combination of things. But state sovereignty ties into separation of powers. And the separation of powers argument is a form of the unitary executive theory that says any enforcement of federal law must be carried out by federal officials and federal personnel so that the president can control whether the law should be enforced, and if so, how. Stevens dissents. He goes back to the Darby truism principle. He says, look, the 10th Amendment and everything that goes with it, the whole idea of federalism, is not a limitation on power once it is granted to Congress in the Constitution. Right? There is no black box. The Constitution does indeed limit powers of Congress. It enumerates those powers and lists them. But once a power is granted to Congress, it is plenary, if you remember that term. Unlike the First Amendment, which prohibits the enactment of a category of laws that would otherwise be authorized, the 10th Amendment imposes no restriction on the exercise of delegated powers. There's not a clause, sentence, or paragraph in the entire text of the Constitution of the United States that supports the proposition that a local police officer can ignore a command contained in a statute enacted by Congress. This is a very live issue, as you know. Lots of states are passing laws saying things like no state official may enforce any federal gun laws or no state immigration laws. It arises actually in a number of areas. Interestingly, the political valency varies. If you're talking about sanctuary cities, then the liberals and progressives are saying, no, we're not going to carry out federal law. If you're talking about gun laws, it's the conservatives saying, no, we're not going to carry out federal laws. But in both cases, the question is it okay for state and local officials to refuse to carry out federal law? And the answer is not only that it's okay for them to do that, it is unconstitutional to try to require them to become instruments of federal policy. Stevens goes back to that debate about tax collecting, and he doesn't see it the same way Scalia does. No fair reading of these materials can justify such an interpretation. The point is made especially clear in Hamilton's statement, and he quotes Hamilton: the legislatures, courts, and magistrates of the respective members will be incorporated into operations of the national government as far as its just and constitutional authority extends. And as Stevens points out, it is hard to imagine a more unequivocal statement, which is clearly true. Of course, it's equally clearly true that Hamilton didn't speak for everyone, right? Just as Scalia's statement that all the founders agreed on a unitary executive is demonstrably false. It's equally demonstrably false to say that because Hamilton said something, that means everybody felt that way. But certainly, Hamilton's position is quite clear. That's not surprising. Hamilton, after all, was the most staunchly nationalist of all the Federalist writers. What about this lack of earlier historical practice? Stevens' response is basically, so what? We have never suggested that the failure of the early Congresses to address the scope of federal power in a particular area or to exercise a particular authority was against its existence. Right? We've never seen an argument of this form before, and as far as I know, that's true. I'm not aware of any case in which any court has ever used that argument. Because Congress didn't do X, that proves it's unconstitutional. Souter writes a dissent just based on reading the Federalist Papers. We went through the Federalist Papers. I suspect you could write this dissent if I asked you to. A little review of your notes, anyway. Breyer dissents. And he points out that the use of local authorities to carry out national policy is fundamental to all federal systems. The federal systems of Switzerland, Germany, and the European Union, for example, all provide that constituent states, not federal bureaucracies, will themselves implement many of the laws, rules, or decrees enacted by the central federal body. Of course, we are interpreting our Constitution, not those of other nations. There's a big debate among justices as to whether it's ever relevant to look to foreign law and practice for guidance. But their experience may cast an empirical light on the consequences of different solutions to a common legal problem. And he asks a pretty fundamental question. Why or how will what the majority sees as a constitutional alternative, the creation of a new federal gun law bureaucracy, better promote state sovereignty or individual liberty? And that's the irony of this principle. The argument is here the federal government cannot use state officials to carry things out, so it needs to create a new federal bureaucracy to do it. This is an argument that says the Constitution requires massive expansion of the federal government if you want to expand the federal government's role. In order to preserve. So what's being preserved here exactly? And the answer is, what's being preserved here is the state's ability not to participate in federal policy. It's not about, well, let's leave it at that. So, the anti-commandeering principle shows up in a bunch of cases, and a bunch of issues, none of them more famous than the Affordable Care Act. Part of the Affordable Care Act was Medicaid expansion. In order to receive federal funding under this new law, states would be required to expand the categories of persons eligible for Medicaid. As you may or may not know, eligibility for federal relief programs are set by the states. Is that not commandeering? I have no idea. Apparently not. So, for example, under the old system of welfare, before welfare reform during the Clinton administration, the old Aid to Families and Dependent Children, each state determined the level of support people could get. In all 50 states, that level was set below the official poverty line, whatever that tells you. States are not eager to spend more money than they have to, or allocate more money than they have to. But there's a long-standing, in this area, long-standing federal-state partnership going back to the 30s, in which federal standards define a certain minimum coverage for Medicaid. I'm sorry, Medicaid's in the 60s. There's a long-standing 60-year-old practice which the federal government establishes minimum standards and states can decide what to do beyond that. The Affordable Care Act contained a provision raising that floor, raising the minimum amount of money and who can get it. This was ruled unconstitutional on the grounds of commandeering. Now, why? It can't be that the problem is that you're requiring state officials to set the standards, as I just pointed out, but that can't be right, because if that were true, Medicaid itself would be unconstitutional. And nothing here suggests that it is. Furthermore, it can't be that as a matter of state sovereignty, well, it's hard, it's paradoxical to argue that as a matter of preserving state sovereignty, we don't want to have state officials set the limits of what their citizens can get. That seems to be the opposite. That seems to be removing state discretion. That's just an odd argument. Why is it that the Medicaid minimum standards that existed a year before the Affordable Care Act were constitutional, but the new ones are unconstitutional? Everybody understand the question and why it's tricky? Roberts writes the opinion. We start with a basic principle. The federal government can put conditions on funds it gives to the states. If the federal government gives states highway funds, they can say you can only use these funds for highways. They can even say you may use these funds for rural roads and these other funds for interstate highways. It's federal money. They can put conditions on it, and states don't have to take it. Don't want to use the money that way? Don't take the money. Right? What's the problem? There's a Pennhurst, old case called, not old, there's a case called Pennhurst with a contract principle, and here's what the principle says. Once the federal government has given money to the states, they can't change the rules. They can't give the states money for road building, and then 2 months later said, oh, by the way, you may only use this money for building rural roads. So far, so good? So when the federal government offers money and the states accept it, that's a contract. This is what Pennhurst says, a contract principle. And you can't change the terms of the contract unilaterally. You've made a deal. Federal government says, we'll give you this money if you use it in this way. States say, okay, we accept that money, we'll use it in that way. That's the deal. The federal government can't change that once it's in place. We've repeatedly characterized spending clause legislation as much in the nature of a contract. That's actually not true. That characterization goes back to Penhurst, which was only about 10 years earlier. It is not the case. This is a long-standing description. The legitimacy of Congress's exercise of the spending power thus rests on whether the states voluntarily and knowingly accepted the terms of the contract. So why is it the case that the federal government can't change the rules about how money is used after they've given it? Because the states didn't knowingly and voluntarily agree to that. Back to that New York principle, remember the case I mentioned that we didn't read, but about you can't force states to carry out federal policy, you can't coerce them. Congress may use its spending power to create incentives for states to act in accordance with federal policies, like if you agree to build a bunch of highways, we'll give you a bunch of money for that purpose. That's okay. But when pressure turns into compulsion, the legislation runs contrary to our system of federalism. So the federal government can put conditions on money that it gives the states, but not if those conditions become coercive. Because federalism is state sovereignty. The Constitution simply does not give Congress the authority to require the states to regulate. Right? No commandeering. This is true whether Congress directly commands a state to regulate or indirectly coerces a state to adopt a federal regulatory system as its own. So our test is coercion. Right? Under commandeering, it was making use of state executive personnel to carry out federal policy. This is the anti-coercion principle that says the federal government can't act in a way that puts coercive pressure on states to agree to something. So far, so good? Okay, what would that look like? I always try to start with an easy example. If you do not raise, this is from a real case actually, if you do not raise your drinking age to 21, we will cut off all of your federal highway funds. That was actually upheld. But it was a discussion about that federal law in which this anti-coercion principle was given form. Was the threat to withhold all highway funds so dire that effectively it coerced states into raising their drinking age? And the answer, well, maybe, but drinking age has to do with highway safety and driving, and it's part of a regulatory scheme, so it's okay. But as a general principle, federal government may not coerce states by imposing conditions on spending. Why? Oh, back to the unitary executive. It would ruin the accountability of the executive branch for federal action. It would put onto the states the responsibility for doing something, and if voters didn't like it, they would blame the states. They would not cast the blame where it properly belongs, which is the federal government, which coerced the states into doing this thing. Permitting the federal government to force the states to implement a federal program would threaten the political accountability key to our federal system. Notice they're doing political science now. In Lochner, they were doing economics. Now they're doing political science. Political scientists don't generally buy this argument, in case you're curious. The term that I've heard used most often is laughable. Spending clause programs do not pose this danger when a state has a legitimate choice whether to accept the federal conditions in exchange for federal funds. Right? In Wisconsin, our government chose not to expand Medicaid, and if we, the voters, didn't like it, we could vote them out and vote in a government that would accept Medicaid expansion. The state had a choice, therefore the state officials, the legislature, was held accountable. Our governor, our courts, and our legislatures, in fact, took 3 different positions on this question, and so, we really had a choice. We could displace or replace whichever of those was acting in a way we didn't approve of. That's accountability. That's the theory. In such situations, state officials can fairly be held politically accountable for choosing to accept or reject the federal offer. But when a state has no choice, the federal government can achieve its objectives without accountability. All right, so there's our political theory as to why this is a fundamental principle. It's tied to federalism of state sovereignty, which says that in order to preserve the sovereignty of the states, we must make sure that they are not coerced or commandeered, but just because they're independent sovereign entities. But it also depends on a political theory argument that says the federal government has to be accountable for its actions. So far, so good? So, what's coercion? Why was the threat to withhold highway funds not coercive, but this one is, right? Go back to the New York case. Okay, we should have written New York. My apologies. In this case, the financial inducement Congress has chosen is much more than relatively mild encouragement. It is a gun to the head. Medicaid spending accounts for over 20% of the average state's total budget, with federal funds covering 50 to 83% of those costs. The threatened loss of over 10% of a state's overall budget is economic dragooning right, commandeering, that leaves the states with no real option but to acquiesce in the Medicaid expansion. So if there's enough money involved, Congress can't put conditions on the way that money is used, because that would be coercive. Think about that proposition. If the federal government, the federal government doesn't have money of its own. The money comes from taxes collected from people, right? So this is people from one set of states sending money to other states. Generally speaking, well, I know this is important or irrelevant, but generally speaking, states that are urban and vote Democratic tend to contribute more than they get. States that are conservative and rural tend to get more than they contribute. There's a general flow of money north to south and from blue states to red states, which is interesting given that politically, the opposition to those programs come from the states that benefit from them the most, which is something you can think about as a political matter. I don't know that it has a particular constitutional implication. So the point is, though, however you set up that system, if the federal government gives the states a little bit of money for something, it can put conditions on it. And if it gives them a lot of money, then imposing conditions becomes coercive. Nothing, in our opinion, precludes Congress from offering funds under the Affordable Care Act to expand the availability of health care. What the state is not free to do is penalize states that chose not to participate by taking away their existing Medicaid funding. So you can have a separate law that says, by the way, if you expand Medicaid funding, then we'll give you more money, but you can't threaten to take away money you've given them in the past, because that would be changing the terms of the contract. Here's the problem with that argument. The Affordable Care Act didn't apply retrospectively. It didn't take away any money that had already been allocated, or threaten to take away any money that had already been allocated to states. It defined the terms for future allocations of money to the states. Under this reasoning, Congress cannot abolish an existing spending program if it's big enough. Or at a minimum, Congress cannot change the terms of a spending program when they reauthorize it. Could Congress have simply abolished Medicaid altogether, adopted a law called Medicaid 2.0, and said, here are its new terms? According to this, the answer is no, at least as I read it. I invite you to consider that question. So our protection of state sovereignty has gone to the point the federal government may not coerce states, it may not commandeer states, it may not put conditions on the receipt of federal money that would have the effect of forcing states to behave in the ways they don't want to. Or in the immortal words of a woman at a protest during the early Tea Party days, keep your government hands off my Medicaid. Which actually was much less ironic than people thought. It wasn't perfectly articulated, but what this woman was saying was, keep your federal government hands off my state-administered medical benefits. And as an assertion of a federal proposition, it's coherent, whether or not it's constitutionally a strong argument or not. All right. Well, we're not done yet. Murphy versus NCAA. And the Murphy is not in your textbook, so I put the case in your notes. So the state of New Jersey wants to legalize sports gambling at casinos and horse track laws, and horse racing tracks, sorry. There's a federal law that makes it unlawful for a state to authorize sports gambling schemes. Question, is this provision compatible with a system of dual sovereignty embodied in the Constitution? So it's the phrasing that turns out to be so important. The question is not, can the federal government ban sports gambling? It probably can, Commerce Clause. But can it prohibit states from authorizing sports gambling? From one perspective, that's a distinction without a difference. Supremacy Clause. If the federal government bans sports gambling, then any state authorization of sports gambling is ineffective. But think about the marijuana case. If the federal government bans gambling, but the state government allows it, the feds can prosecute you, but the states can choose not to. Just like rape and possession of marijuana, right? If the states have legalized marijuana, our current situation, some states have legalized marijuana for recreational purposes. Ours is not one of them, however you feel about that. But the feds still arrest people for dealing marijuana, contrary to federal law, right? That's okay. That's not using state officials or state law to carry out the federal policy. With me? All right. So why is this unconstitutional? This is unconstitutional because that word authorize, the prohibition on states authorizing something, commandeers the legislature. You can commandeer the judges. You can tell the judges what laws they may and may not enforce. But you can't commandeer the executive, and you can't commandeer the legislature, because that would violate state sovereignty. The state relied on the commandeering cases, particularly Prince, that we just read about the Brady Bill. Relying on these cases, New Jersey argues that the law is similarly flawed because it regulates states' exercise of its law-making power by prohibiting it from modifying or repealing its laws prohibiting sports gambling. Do you remember a prior case that said the federal government can prohibit states from enacting certain laws? Prigg, the Fugitive Slave Act. But in that case, we were told the federal government could require states to pass certain laws and prohibit states from passing laws that require slave catchers to come before, to go through procedures before they kidnap people off the streets. Now we are told that the state that this is in fact a violation of a basic constitutional principle of federal sovereignty because it's the federal government directly controlling actions of the state legislature. When a state completely or partially repeals old laws banning sport gambling, it authorizes that activity. And he goes through the history of the laws that were at stake in this particular case in Florida. He says the concept of state authorization makes sense only against the background of prohibition or regulation. A state is not regarded as authorizing everything it does not prohibit or regulate. In other words, the word authorize, you say states may not authorize something, you're assuming states have laws in place governing that activity, in which they authorize it sometimes and not other times. Therefore, you're telling states to decide what it should authorize and what it should not authorize within its legal scheme, and this has the effect of directly compelling state legislatures to pass certain kinds of laws and not others. The anti-commandeering doctrine may sound arcane. I've already admitted I find it arcane, but it is simply the expression of a fundamental structural decision incorporated into the Constitution, the decision to withhold from Congress the power to issue orders directly to the states. When the original states declared their independence, they claimed the powers inherent in sovereignty. In the words of the Declaration of Independence, the authority to do all acts and things which independent states may of right do. Yes, we are back to the Declaration of Independence. We are back to the debate between Federalists and Anti-Federalists. This is why the compact theory keeps coming up in this class, and state sovereignty and I realize some of you must be really tired of hearing about sovereignty, but it is the current issue in modern Supreme Court doctrine on questions of federalism. And the argument is that the Constitution has to be read in a way that is consistent with the Declaration of Independence, i.e., it is not possible or permissible to read the Constitution as having changed the status of states as sovereigns. A direct contradiction, of course, to Hilton versus Ware, 1796. You remember the case in which I believe it was Chase goes through the history, 1774, 1776, Articles of Confederation, Constitution, and he argues that the status of the states changes. No. The status of the states does not change, arguably cannot change. It remains what it was at the moment of Declaration of Independence, and the adoption of the Constitution is merely carrying that understanding into effect. The Constitution limited but did not abolish the sovereign powers of the states, which retained a residual and inviolable sovereignty, quoting Federalist 39. Thus, both the federal government and the states wield sovereign powers, which is why our system of government is said to be one of dual sovereignty. The Constitution confers on Congress not plenary legislative powers, precisely what Marshall said it did do, but only certain enumerated powers. All right, so why does this make sense? Why is this argument, I mean, we get what the argument is, right? And we get the claim that it's grounded in the understanding of the Declaration of Independence, but back to that political theory question. How do you explain it? So the explanation before was about accountability, remember? Federal government has to be accountable for its actions. The federal government can tell the states what to do. That gets in the way of that. Here are some different arguments. First, the rule serves as one of the Constitution's structural protections of liberty. The Constitution does not protect the sovereignty of states for the benefit of states or state governments as abstract political entities. The Constitution divides authority between federal and state governments for the protection of individuals. Question: how is this protective of the liberty of individuals? And I'll be honest, I have no idea. No, I'm not being snarky here. It's entirely possible this is simply an argument written by people who are much smarter than I am, because I don't get it. Second, the anti-commandeering rule promotes political accountability. Right? The vast majority of the time, in fact, federal law infringes on states' authority to make decisions in the interest of promoting individual liberties, especially under 14.5. It is difficult for me to come up with an example, even a hypothetical example, where the anti-commandeering principle can have the effect of promoting individual liberty, as opposed to simply meaning you have to make a federal bureaucracy to do this, as opposed to having the states do it. Maybe that's the answer. Maybe the answer is that because this principle raises the financial costs involved in the federal government engaging in a scheme of regulation, it makes it harder for the federal government to do that. The problem with that argument from a liberty perspective is that it assumes that states are not a threat to liberty. That the only threat to liberty could be regulation by the federal government rather than regulation by the state government, because after all, Congress prohibiting the state government from doing something is exactly what is declared unconstitutional here. Second, the anti-commandeering rule promotes political accountability. Third, the anti-commandeering principle prevents Congress from shifting the cost of regulation to the states, the argument that I just made. All right, there's then a lengthy discussion of preemption, which is included here only for your review. Alito goes through the three different versions of preemption. It's a nice summary. I don't want to go through it right now. It would take too long. And honestly, okay, this is, it's awfully late in the semester to be saying this, but this is done wrong. I should have put this case excerpt onto Canvas and then made notes about it. These are just imperfectly polished notes. I will improve them and put up improved notes later today. My apologies. I don't know what else to say. All right, so we have these new principles of state sovereignty and understandings of federalism. An anti-coercion principle and an anti-commandeering principle, right? And the arguments are that these are grounded in the state's identities as sovereign entities going back to the Declaration of Independence. Right, so a very strong position of that fundamental dispute that we've seen all along throughout our history on the question of the relationship between the states and the federal government. Are we one people or 13 peoples? All that stuff. Also based on certain sort of political, what I'm characterizing as political science, justifications about cost shifting and accountability. Yeah? And a closing principle that said, not a closing principle, and an interesting pattern that you can distinguish all of the obvious examples of what looked like commandeering in the Constitution, the militias, taxation, tax collection. You can distinguish the Supremacy Clause. If you look carefully enough, you can distinguish all those. And now my question is, how? And the answer, I think, goes back to usury. That is, are we commandeering states as states? So what are you allowed to do and what are you not? What is Congress allowed to do and what is Congress not allowed to do? Congress is allowed to tell state courts what laws they must not enforce. Congress is allowed to call, and the president is allowed to call into action the state militias and use them to enforce federal law and put down insurrections. If you think about insurrection as a possibility of a state seceding, for example, this is a direct opposition between the federal government and the state. This is what happened at Little Rock. I believe I told this story, but after Eisenhower sent the 101st Airborne to stare down the Arkansas National Guard, 2 weeks later, he nationalized, he called into federal service the Arkansas National Guard, and from then on, the National Guard enforced federal desegregation laws. Because that's what you can do with the militias and with the National Guard, right? So but what you cannot do is tell the legislature what laws to pass, and you cannot make the members of the executive branch perform the actual actions involved in enforcing federal law. What distinguishes those two categories? One answer is you throw up your hands and say, who knows, they're all just making it up, this is all politics or something like that. I think a much better answer is, this is a revival of a version of the usury principle. The idea that these are state core functions. That in the same way it is the core function of the federal executive in separation of powers terms to determine how and whether to enforce laws, it is the core function of the state's executive branch to determine whether and how to enforce laws. And if the Congress can make state officials enforce certain laws, they're being deprived of their discretion in carrying out their executive functions. If it is the function of the state legislature to make laws, as of course it is, right, you can't commandeer that because that deprives the state legislature of its essential function. By contrast, it is not the essential I don't know. By contrast, state courts and the militias and tax collection are different. That's the argument. That's the principle that's asserted here. I'm claiming that it's brand new. I'm also claiming, not very subtly, that it's very hard to see how this is grounded in the text's original understanding of the Constitution. However, it's very easy to see that what's going on here is a reviving of doctrines of state sovereignty and a form of federalism that would constrain the federal government in significant ways, particularly the ACA case. The argument that the federal government cannot, in enacting new funding, this is not retrospective. When we authorize next year's funding, or 5 years from now, or 10 years from now, we can't put any new conditions on that funding if there's a lot of money involved. Because as a political matter, that would have the effect of coercing the states, a kind of several steps removed implication of infringement on sovereignty, very, very different from the resistance to those kind of extended implications that we've seen in other areas, like defining the scope of Congress's Commerce Clause. So we're going to read the limitations on Congress's powers very broadly, with these principles of interpretation that go way into the weeds of implication and structure and philosophical principle, but we're going to read grants of power narrowly, or more narrowly than we used to. All right, all of that is within arguments about the Constitution, what it says and what it does. Right? All of this is a debate about Article 1, particularly Article 1, Section 8, and implied principles of federalism and state sovereignty. Then we get to Alden versus Maine. Alden versus Maine is actually one of about 8 cases declaring the same principle in different contexts. At the end, I'll come back and review what a couple other ones said. It's a principle of sovereign immunity. You know how in this course, I'm always like going back to the beginning? Yeah, this one's going to hurt. This is Chisholm versus Georgia. We're going back to 1793. Literally the first major Supreme Court case ever is back on the table. Now we know that the 11th Amendment was adopted to overturn the effects of Chisholm, just as RFRA, remember City of Bern last time, was adopted to overturn the effects of the decision in Smith. There is, if you like, precedent for that sort of thing, right? And we know what the 11th Amendment said. You can't sue an individual from one state may not sue another state in federal court. And you remember the arguments about it. Well, if that's true, how can that be true, since the Constitution specifically says federal courts have jurisdiction over suits between states and citizens of another state? Yeah, but there's an implied principle that that's only true when the state is the plaintiff, not when the state is the defendant. So you can't drag a state into court against its will. How is it possible that the people who wrote Chisholm, who signed the Constitution, didn't understand this? Who knows? But on the other hand, the politics was very clear. This was the Democratic-Republican resistance to the Federalist domination of the branch. Remember all that background stuff? I know this is the beginning of the semester feels like a long time ago. And 1793 feels like a long time ago. What is striking about today's materials is how fundamental to our constitutional order the issues are. Alden versus Maine. What is the scope of states' immunity from being sued under the 11th Amendment? Now, if you read the 11th Amendment, it's very straightforward. No state may be sued in federal court by a citizen of another state. Actually, technically, without its consent. The states effectively never consent to that, but let's be fair. Without it, no state may be sued without its consent by a citizen of another state in federal court. Alden versus Maine didn't involve that. Alden versus Maine involved citizens of Maine suing Maine, a state being sued by citizens of the same state in federal court. And the conclusion is that is unconstitutional. Why? Well, the problem for the argument, pardon me, the problem for the argument is the one I just said. The 11th Amendment seems pretty simple. You may like it or dislike it, and you may approve or disapprove. You can go back to Federalist debates, Chisholm, whatever. But what it says seems pretty straightforward. A state or a citizen of another state. How do you get from that to a constitutional ban on a suit against a state by a citizen of the same state? Kennedy writes the opinion. It's a 5-4 opinion. They're all 5-4 opinions. Like I said, there's half a dozen of them. What's interesting is that they're each written by a different justice. It is my interpretation. It is as though they wanted to make it very clear this is not one justice's theory. So Kennedy writes one, Scalia writes one, O'Connor writes one, right? You know how the assignment process works? If the Chief Justice is part of the majority, he gets to assign the opinion. On these sovereign immunity cases, Rehnquist took great care, and later Roberts took great care, to assign them to all the different justices who were on the correct side. And they all say the same thing. This is an example. So, there was an earlier case called Seminole Tribe of Florida versus Florida in 1996. That was the case that announced this principle of sovereign immunity. That one said no suits are allowed by citizens of a state against the state in federal court. We didn't read that one because the reasoning is the same as this one. I'm just giving background, right? So, but we already have a case that says you cannot sue your own state in federal court. Are you with me? Alden versus Maine is even more complicated. It's in state court. A citizen is suing, it's actually prison guards, who complain they are being paid less than the minimum wage, in case you're curious about the background. Citizens of Maine are suing Maine in a state court. And this is said to be barred because the 11th Amendment says a citizen of one state may not sue another state in a federal court. How do you get there? Citizens of Maine are suing their own state in a state court under a federal law. Here we go. And the opening sentence should get your attention. The sovereign immunity of the states neither derives from nor is limited by the 11th Amendment. There's nothing to do with the 11th Amendment. We were all wrong to be looking there. We all got the history wrong. Nothing to do with the 11th Amendment. Why not? Rather, the state's immunity from suit is a fundamental aspect of the sovereignty which states enjoyed before the ratification of the Constitution and which they retain today except as altered by the plan of the Convention or certain constitutional amendments. So this is not about the 11th Amendment, which raises an obvious question. What's the 11th Amendment for? We'll come back to that. But remember, we're not quoting the text at all. This is about background sovereignty. We did not find in the Constitution, you have to go through the reasoning this way. It is an infringement on state sovereignty to allow states to be sued in their own courts by their own citizens. We did not find that the Constitution specifically gave citizens the authority to sue their own states in their own states' courts. Therefore, the Constitution prohibits citizens from doing that. Because the implication of the Constitution is that anywhere it doesn't infringe on state sovereignty, it is preservative of the state sovereignty that existed before the ratification. This is a complete rejection of the Federalist theory that the national people got together and decided these powers of the federal government, these powers of the state's government. This is a complete embrace, a wholehearted embrace of the idea that the states are sovereign nations who've given up certain prerogatives, but only those prerogatives. And so if you want to know what powers the nations of Europe retain under the European Union, you look at the treaty that formed the treaties, the Lisbon treaties, that formed the European Union, and you say, was this power granted to the EU? It was not. It remains with the states, the member states. That's the reasoning that is going on here. But notice, it's more than that. Because it doesn't just say this is left to the states. It would be unconstitutional for the federal government to say that that lawsuits may be brought against states by citizens of their own states, by citizens of other states, in federal court, by anybody, because that would infringe on state sovereignty. The Constitution specifically recognizes the states as sovereign entities. What's the authority quoted for this? The 1996 Seminole Tribe case. This is what's called, you know the term bootstrapping? You imagine someone bending down, grabbing their boots, and pulling themselves up into the air. That's bootstrapping. This is pure bootstrapping. They go back as far, they had a case where it said states are sovereign, said, oh, we said states are sovereign, that's our authority for saying this next thing. Any doubt regarding the constitutional role of the states as sovereign entities is removed by the 10th Amendment, which of course directly contradicts Darby and National Labor, NLRB versus Laughlin, and pretty much everything we've read this semester. What is it that state sovereignty requires? What's our guiding principle? How do we know? The answer is dignity. States, unlike individuals, are entitled to dignity. I say unlike individuals, you have to take 412 to learn about exactly how that works, but for the moment. First, it reserves to them a substantial portion of the nation's primary sovereignty, together with the dignity and essential attributes inherent in that status. So the primary sovereignty of the nation resides in the states, not the people. And they are therefore entitled to be treated with dignity. Second, even as to matters within the competence of the national government, right? So this is that black box again, right? Even if a power is granted to the national government, the constitutional design secures the founding generations' rejection of the concept of a central government that would act upon and through the states in favor of a state in which the state and federal governments would exercise concurrent authority over the people. What's the authority? Prince. The Brady Bill case that we just read, or just talked about. So dual sovereignty means the state governments can regulate people and the federal government can regulate people, but the federal government cannot regulate the states, and presumably vice versa. The states cannot regulate the federal government. Of course, that's not really an issue, but under the Supremacy Clause, you might have thought that the former was. When the Constitution was ratified, it was well established in English law that the Crown could not be sued without consent in its own courts. So the dignity of states is the dignity that attached to the King of England. That's what it means to be a sovereign. What about Chisholm versus Georgia? I'm glad you asked. That case was wrong. It's not that the 11th Amendment changed it. It's not really an amendment at all. Chisholm was just wrong. And the people who ruled it were wrong. Jay and Wilson and Chase simply didn't understand the Constitution that they had signed. I'm sorry to reemphasize that point, but it does get me a little worked up. The court's decision fell upon the country with a profound shock. The states in particular responded with outrage to the decision. That's quite true. Massachusetts, did I mention this, was being sued and joined in the argument. By its terms, then, the 11th Amendment did not redefine the judicial power. Right? So where Article 3 says lawsuits between states and citizens of another state, the 11th Amendment didn't change that. It just corrected the mistake. It did not redefine the judicial power, but instead overruled the court. It is doubtful that Congress meant to write a new immunity into the Constitution. It would have limited that immunity to the narrow text of the 11th Amendment. In other words, it's the drafting error theory. There was always an intention that states should have this immunity. Article 3 was just written badly. They just goofed. They failed to mention this immunity thing. The 11th Amendment didn't change Article 3, it corrected that error. After all, if there had been an intention, if there had actually been an intention in drafting the Constitution to limit state sovereign immunity, surely it would have been written in a way that preserved more sovereign immunity than Article 3 appears to do under the mistaken reading of Chisholm versus Georgia. At some point, you might want to consider the question of what is the meaning of the phrase judicial activism, but we don't really have time for that. So the 11th Amendment did not create any new immunities. It simply overruled an erroneous ruling by the Supreme Court and restored the state sovereignty that was already present, the immunity that was already present in the Constitution, even though the Constitution doesn't say that, because we know that if they had written it properly, they would have intended to preserve for the states the dignity that attaches to the King of England. With me? By the way, as a statement of English law, that's absolutely wrong. It is quite true that you could not sue the king, because there was a theory that the king cannot act unlawfully. The workaround was that since at least the 18th century, actually the 17th century, you can sue the king's ministers. You can sue the government and claim what you're doing is wrong, therefore it must not really be the king's will. So the person of the king, that dignity is protected against being sued, but no actions of the king are protected against being sued in English law, going back to at least the 18th century. There's a Hebrew word for the argument the court is using here, bullshit. It's one of the irregular terms. All right, so the drafting error theory says Article 3 was miswritten, the 11th Amendment fixed the error. Article 3 was supposed to say cases between states and citizens of other states where the state is a plaintiff, and the 11th Amendment restores that original understanding that was missed by Wilson and Chase and Cushing and Jay. Just as a reminder, Jay co-authored the Federalist Papers, Wilson signed both the Declaration of Independence and the Constitution, Chase also signed both the Declaration of Independence and the Constitution. Whatever. And again, we dive into political theory. How do we know this is the right reading? Because any other reading is one we assume the states would not have agreed to at the time of the Constitution. Not only do the ratification debates and events leading to the adoption of the 11th Amendment, not the Constitution, the 11th Amendment, right? We're jumping. Reveal the original understanding of the state's constitutional immunity from suit. That is, if we assume that the drafters of the 11th Amendment thought what they were doing was correcting an error in the Constitution, rather than in the more usual sense of the term, amending it, well, then we can assume that whatever they said about the 11th Amendment reflects the earlier understanding of the Constitution itself. You with me? It's a complicated little dance. Not only do the ratification debates and events leading to the adoption of the 11th Amendment reveal the original understanding of the states' constitutional immunity from suit, they also underscore the importance of sovereign immunity to the founding generation. Simply put, the Constitution never would have been ratified if the states and their courts were to be stripped of their sovereign immunity. How do we know? We just do. To be sure, some members of the founding generation disagreed, but these were a small minority, says Kennedy. And we know their names. Chase, Wilson, Cushing, Jay, Madison. So what we have here, in other words, is a form of originalism that has abandoned the text altogether. The text will be made to conform to the original understanding, not the original understanding will be used to interpret the text. We don't care what the text says. Our job as a court is to enforce the historical background and understanding, in this case, of the sovereign dignity of states against a threat posed by what's written in the text of the Constitution. The court has been consistent in interpreting the adoption of the 11th Amendment as conclusive evidence that the decision of Chisholm was contrary to the well-understood meaning of the Constitution. What's the authority for this? Seminole Tribe, 1996. As a consequence, we have looked to the history and experience and the established order of things rather than adhering to the mere letter of the 11th Amendment. We don't need words or text. We're the Supreme Court in determining the scope of the state's constitutional immunity from suit. I know this is violating all these paper-thin norms of neutrality I've been trying to maintain all semester. I can't. I cannot present this as anything other than what Scalia once called argle-bargle. To rest on the words of the amendment alone would be to engage in the type of ahistorical literalism we have rejected in interpreting the scope of the state's sovereign immunity. Right? Nowhere else. Bootstrapping. Because in 1996, when we considered state sovereign immunity, we did not think we should look to the texts of the Constitution. That proves that we never have to look to the text of the Constitution when considering questions of state sovereign immunity. Why? That would be ahistorical literalism, and we're not in the text business, we're in the restoration of history business. Today, as at the time of the founding, the allocation of scarce resources among competing needs lies at the heart of the political process. Right? Doing that political science thing again. While the judgment creditor of the state, that is the person to whom the state owes money, remember this all started about war debts, way back when, from the Revolutionary War against Georgia. While the judgment creditor of the state may have a legitimate claim for compensation, other important needs and worthwhile ends compete for access to the public fisc. The states have to have the freedom not to pay their debts. Go back to Chisholm. Will the state, having incurred a debt, be allowed Proteus-like to declare itself sovereign and not pay it? Such a thing would be unthinkable. Want to bet? Because Chisholm was wrong. If the principle of representative government is to be preserved to the states, the balance between competing interests must be reached after deliberation by the political process. So one interest is, what was the essence of civil liberty in Marbury versus Madison? To have access to the courts, to assert a claim for a vested right. Not anymore. Not if a state is involved. The question of whether a state, what's the core vested right? Property claims. Way back in the beginning. I know we aren't exploring rights particularly deeply in this class, but right way back at the beginning, the very first week, there's a competition between the Constitution as a political or a legal document, a competition between rights as legal claims or political prerogatives, a competition between different, and it's not as though there was only one answer. That was the Kramnik article. There were different philosophies around, and people had different views of what we were talking about, right? With Marbury, Marshall declares strongly, we do law. Law is about law-like stuff, and law-like stuff means property, invested claims to property, and it is the essence of civil liberty that if a private individual is owed money, they can go to court to collect it. Not after 1996. The essence of civil liberty, we are now told, is letting the state politics determine whether debts will be paid or not. I'll read it to you again. While the judgment creditor of the state may have a legitimate claim for compensation, other important needs and worthwhile ends compete for access to the public fisc. The state may want to do things with its money other than pay its debts. If the principle of representative government is to be preserved to the states, the balance between competing interests must be reached after deliberation by the political process established by the state. As a result, Congress may not pass a law that allows suits against states, which was the Fair Labor Standards Act, which was the law these prison guards were suing under. Irrespective of in state court, in federal court, that doesn't matter. The point is not what Article 3 says. The point is not what the 11th Amendment says. The point is to respect the dignity of sovereign states. When Congress legislates in matters affecting the states, it may not treat those sovereign entities as mere prefectures or corporations. Congress must accord states the esteem due to them as a joint participant in a federal system, one beginning with the premise of sovereignty. The framers of the Constitution do not share our dissenting colleagues' belief that the Congress may circumvent the federal design by regulating the states directly when it pleases to do so, including by a proxy which individual citizens are authorized to levy upon the states. Right? What we have here is the federal government saying to individuals, you are authorized by federal law to make a claim against state funds. That violates the dignity of states ensured by state sovereignty in the same way as commandeering and coercion. That is Congress infringing on the dignity of states. Seward dissents. He raises a question that I've already kind of alluded to. Okay, maybe it's true that in colonial times there was a belief that the King of England had certain immunities. What's the evidence that the founders of the Constitution intended the Crown's immunities, that bit of English common law, to be imported to the United States and attached to the states? While sovereign immunity entered many new state legal systems as part of the common law selectively received from England, it was not understood to be undefeasible or be given any such status by the national constitution. Some state constitutions had sovereign immunity principles, some didn't, and there's no discussion of that in the Constitution or the debates around the adoption of the Constitution, which is why the majority had to look to debates about the 11th Amendment. The court's principal rationale turns on history. It was the natural law's conception of sovereign immunity as inherent in any notion of independent state widely held in the United States in the period preceding ratification? The answer is certainly no. There's almost no evidence that the framers thought sovereign immunity was fundamental in the sense of being unalterable. Goes through some of the disagreements among the founding generation, including the Federalist Papers. And he also points out the point that I've made repeatedly: the majority's theory in this case, and in Seminole Tribe, and in other cases, was rejected by all of the 5 different opinions in Chisholm versus Georgia. How could all of those founders have been so wrong about the fundamental meaning of the Constitution? And that is one of the enduring mysteries of American constitutionalism with which I will leave you. In a sense, this is the end of the course, because of course there's a lecture on Tuesday and there's material for that lecture, but it kind of veers in a slightly different direction. In terms of the shape of our understanding of American constitutionalism, this is where we're at. States' sovereignty has been restored and reasserted. It is a new and more powerful form of state sovereignty than we've ever seen in our history before. That has the effect. In the other cases I mentioned, the principle of state sovereignty was used to say that states are immune from being proceeded against before agencies. State courts, federal courts, citizens of other states, citizens of the same states, agency proceedings, or any other proceedings instituted by federal institutions. In all of them, states are immune. In one of the best one's a case called Florida Prepaid. The state of Florida engaged in commercial fraud. They had a student loan program, and they had an advertising campaign for that student loan program, and it was found that advertising campaign was fraudulent. But the suit against them was dismissed on grounds of sovereign immunity. States are immune from states that engage in commercial transactions and engage in fraud are nonetheless immune from being sued for having done so under any federal law, go back and read Chisholm. And that's it. And on Tuesday, we will talk about the missing piece of all this is, well, what about politics? What about democratic politics and elections and the way that we're all supposed to have the ability to respond to, among other things, constitutional visions that we might approve of or disapprove of through the electoral process? We'll talk about that next time. And again, I apologize for these notes. I will fix them and have a new version posted either today or tomorrow. Tomorrow at the latest.